Head Note A. Extension of tenure of Director Enforcement Directorate. Extensions in breach of Mandamus. Extension of tenure granted to Respondent number 1 holding the post of Director of Enforcement after attaining the age of superannuation challenged in earlier writ. It was held that extension of tenure granted to officers who have attained the age of superannuation should be done only in rare and exceptional cases and only for short period, and court made specific order not to grant further extension. Despite that, Union of India granted 2 more extensions. Breached the order of Mandamus. Orders of extensions held to be illegal. Considering the concern expressed by the Union of India with regard to FATF review and that process of appointing the Director of Enforcement is likely to take some time, to ensure the transition to be smooth in the larger public interest, Respondent number 2 permitted to continue to be in office till 31st of July 2023. Head Note B. Constitutional validity of amendment to Section 25 of 2003 Act, subsection 1, of Section 4B of 1946 Act and Clause D of Rule 56 of 1922 Rules. Extension of tenure of Director Enforcement Directorate. Amendments empowering government to extend the tenure for a period of 1 year at a time, subject to a maximum number of 3 such extensions. Plea that such a provision empowers government to permit piecemeal extension of tenure of the Director of CBI 1 year each subject to a maximum cumulative tenure of 5 years undermines the independence and integrity of the office, has the effect of wiping out the insulation of these offices from extraneous pressures. Held that it is not at the sweet will of the government that the extensions can be granted. It is only on the basis of the recommendations of the committees which are constituted to recommend their appointment, and that too when it is found in public interest, and when the reasons are recorded in writing, such an extension can be granted by the government. Constitutional validity of aforesaid amendments upheld. Head Note C. Legislative enactment. Presumption is in favor of the constitutionality of a legislative enactment. Legislative enactment can be struck down on the ground of lack of legislative competence to make the law, if it takes away or abridges any of the fundamental rights enumerated in Part 3 of the Constitution, or any other constitutional provisions, and on ground of manifest arbitrariness.